Good afternoon, everyone, and thank you for joining us. My name is Eve Green Coopersmith. I am a partner of Garfunkel Wild in charge of our elder law practice group. And I am joined today by Doris Martin, who is as I said, my partner at Garfunkel Wild in charge of our Trust and Estates Department. We're going to be speaking today about personal advanced care planning at the time that we're all in at this pandemic. And how we can think about our advanced directives and our estate planning needs and try to attend to them now if we have not yet done so. So let's get started. Hold on a moment. Oh, there we go. I do apologize. I am working remotely, so it doesn't always work exactly as one expects with the computer. I should also say that this webinar is being recorded, and everyone who is registered will have an opportunity to have the slides as well as the recording, so you may share with others that you find helpful to you. So part of why we come to this presentation is on April 16 every year, it's National Health Care Decisions Day. And the purpose of National Healthcare Decisions Day is to try to educate and empower members of the public and healthcare providers regarding the importance of healthcare planning and to also provide information and an opportunity to individuals to be able to document their healthcare decisions. So we want to really inform the public and everyone as to the options with respect to advanced care planning and encourage people to make those decisions. And, you know, maybe I'm showing my age a little bit, but if we think about the Terri Schiavo case, which really was in the news for about 15 years in the 1990s and early 2000s, that was just a horrible situation where a young woman as a result of a medical condition was in a persistent vegetative state and being maintained on life-sustaining treatment, in particular a feeding tube. And a dispute arose between her husband, who said this is not what she wanted, and her parents, who said no, she should be maintained on life support. And so part of what we're doing with respect to advanced care planning is to recommend to everyone that you have an advanced directive, more than one, and we'll talk about the different types today, to ensure that you're not in that position of Terri Schiavo and your wishes can be followed, whatever they may be. So the first thing we want to say, of course, is stay home, stay safe, and to the extent that you can contact your attorney to help you execute these documents now if you need to, there are ways to do that. So the types of documents we're going to talk about in today's presentation include advanced directives, which include appointing a healthcare agent, making a living will. There's something called a MOLST form or a POLST form. We'll talk about what that is. A power of attorney, which controls your property. Making a will to control what happens in the event of your passing. We'll talk about organ and tissue donation and the disposition of remains after your death. Now, in New York, New Jersey, and in Connecticut, as a result of this public health emergency that we are in, there are rules that have been put into place as to how to execute documents remotely, how to get things witnessed and notarized using video conferencing technology. There are specific conditions, it's complicated, and we'll talk about that. But first I want to really talk about what are all these different documents that we're talking about, and how, you know, what are the forms that you can use and how do you go about making them. So the first type of advanced directive we're going to talk about is the appointment of a healthcare agent or a healthcare representative. You may name someone who you trust to act as your agent or your representative to make healthcare decisions on your behalf in the event that you're unable to make these decisions for yourself. New York, New Jersey, Connecticut all have different types of forms that do the same thing. The way they work is that once you're determined not to have capacity yourself to make medical decisions, and that's usually determined by your attending practitioner, your attending physician, then your agent or representative would be empowered to make any and all medical decisions on your behalf. Your agent would be entitled to access medical information from your treating providers in order to make those medical decisions. And there are decision-making standards, which we'll talk about, but first and foremost, an agent that is appointed by you must make decisions consistent with your wishes. You can state your wishes on the proxy form itself, the document that you're signing to appoint this agent, or it could be made on another type of advanced directive. And once you regain capacity to make your own medical decisions, the authority of your healthcare agent ceases. So the way I explain this to people is, if God forbid I'm in a car accident, and when I come to the hospital, I'm so injured that I don't have capacity, my agent would be able to make appropriate medical decisions for me. Once I'm better, then I make the decisions for myself. And an agent does not have the right to just access your medical information at any time. They're only entitled to access your medical information when their authority to make medical decisions for you is in effect. So using my same example, right now I'm fine. My agent has no right to access any of my medical information unless I were to give it to them in some other means. Unless I sign a HIPAA authorization, something like that. I have to sign some written consent. So the agent's authority is only triggered when my doctor determines that I don't have capacity. So it's important to understand that there are limitations to how the agent accesses information. So as I said before, decisions must be made in accordance with your wishes, to the extent that your wishes are known. And if they're not known, then in accordance with your best interests. All agents have the authority to make decisions about life-sustaining treatment, but it is subject to any limitations that you set forth either on the proxy document or in a living will. And there are some specific rules with respect to life-sustaining treatment in particular that states do have. So for example, in New York, it says very clearly in the healthcare proxy statute that a healthcare agent may not make decisions about tube feedings and IV hydration unless the agent knows your wishes or can ascertain your wishes with reasonable diligence. So there has to be a conversation between you and your agent as to what your wishes are. In New Jersey, there's a strong recommendation that when you sign a proxy directive naming an agent or a representative to make healthcare decisions for you, that you also specify your wishes with respect to life-sustaining treatment. And there's a separate type of instructional directive that you can also sign in New Jersey. So there are certain rules, in each state with respect to life-sustaining treatment. In New York, the document is called a healthcare proxy. There is a form that the New York State Department of Health has created, which is a healthcare proxy. And on this slide, I've given you the link to that form. And the first thing I'll tell you as a healthcare lawyer, I am an elder lawyer, but Garfunkel Wild also represents many healthcare institutions, and I've seen healthcare proxies in practice. I've had to look at them that are created by individuals to determine if they're valid. What I always recommend to our clients, our individual clients, and everyone who asks about a healthcare proxy is use the state form. And I would say that in any state, use the state form for the appointment of an agent. And the reason for that is you don't want the attorneys involved. You want your healthcare provider to look at the form, see that all the blanks are completed where they're supposed to be completed. It looks like it's valid. It's valid. We're going to just honor it. We're going to honor it, and we're going to follow the agent's directions. You want it to be effective. So the most effective way is to simply use the state form, and that should be your model. And that's what we do at Garfunkel as well. So in New York, the way it works is you have to choose one person at a time as a healthcare agent. You can name someone else to serve as a backup. And very often, my partner, Dee Dee, will tell you that we get families that come in and say, but I love all my children equally. I want them all to be able to make decisions for me. The way it works is you have to name just one at a time. You can name them all, but they can only serve one at a time. So one, then the other, then a third. You should always indicate on the proxy form the address, the cell phone number, whatever contact information you want the healthcare provider to be able to reach out. There's got to be a phone number where they can reach the person that they need to contact. So it should be a cell phone number. You might want to include a home phone number as well, if there are two different phone numbers available. And that should be very clearly indicated on the proxy document itself. In selecting an agent, choose someone you trust. I remember having a client who said to me, you know, I really love my family, but they're not going to honor my wishes. And I have very specific wishes. So I need to appoint someone else, a friend who I trust will honor the wishes that I have. So it's important that you choose someone you trust. The proxy must be signed in the presence of 2 adult witnesses. Neither of the witnesses can be one of the named agents. So you have to choose other people. So it can't be the agent or alternate agent. No notary is required in New York. The New York State form and many of these forms were created so they could be signed around a kitchen table, so that you don't need an attorney to sign the form. And the other very important thing I would say, and always recommend, is that you talk to the agents that you're appointing about your goals and preferences concerning treatment. It's important that that those who you're naming to be your medical decision maker know what your wishes are, and know what your wishes are with respect to cardiopulmonary resuscitation, with respect to tube feedings, with respect to IV hydration, with respect to antibiotics, so that if you were in a situation where you have an irreversible or incurable condition with no reasonable hope of recovery, no meaningful ability to communicate, do you want those types of measures to be utilized? You might say yes, in which case you want to make sure your agents know that's your choice. You might say no, absolutely not. If I have no reasonable hope of recovery, I don't want to be maintained on these measures. So it's important to have those discussions with your agents. In New Jersey, the type of document to appoint a healthcare agent is called a proxy directive. It used to be known as a durable power of attorney for healthcare, and in some other states, it's still known as a durable power of attorney for healthcare. But in New Jersey, it's now called a proxy directive. I've provided you here on this slide with the link to the New Jersey form for a proxy directive. And these are easy to understand and easy to follow. Again, it's similar to the New York proxy, where you choose one person to act as your healthcare representative. In New Jersey, it's often referred to as a healthcare representative as opposed to a healthcare agent, but it's the same thing. And you can name an alternate representative. Again, it must be signed before 2 adult witnesses, neither of whom can be appointed as an agent or as a representative or as an alternate representative. And in New Jersey, there is an alternate option of signing a proxy directive before a notary public. And in this way, it would have to be signed and acknowledged. So it's not, there's a technical term to something that's signed and acknowledged. It's the way that you transfer real property. It's a little bit more involved, but you can do it before a notary. In Connecticut, this type of appointment is known as the appointment of a healthcare representative. The form actually says appointment of healthcare parens agent and then representative. And again, I have provided you with the link to the instructions and form for completing a Connecticut appointment of healthcare representative. You choose one person, you can name an alternate, you can sign the proxy directive, in the presence of 2 adult witnesses, neither of whom is the representative. And in Connecticut in particular, there is in addition to the 2 witnesses, there's a separate witness statement that is attached to this proxy form. And it's an affidavit that the witnesses sign that says that you appeared before them and you appeared to have sound mind and you exercised this proxy willingly and free from duress. Now, all of these proxy forms that I'm talking about, the appointment of a healthcare agent, they all have that type of language embedded right before the witnesses sign. But in Connecticut, if the witnesses sign this affidavit, and any affidavit has to be signed before a notary public, if they sign this affidavit, then if there's any challenge to the proxy, that affidavit avoids the witnesses having to come to court to testify, because it helps to prove the validity of the document itself. So it's strongly recommended that when a proxy, when in Connecticut, when you appoint a healthcare representative, you have the witnesses, in addition to witnessing your signature, you have them also sign the affidavit before a notary. So let's talk about a living will, because everyone understands what a living will basically means. And what it is it allows you to express in writing what your wishes are concerning medical treatment in the event that you develop an irreversible or incurable condition that prevents you from expressing your own decisions at that time. So it is a document that applies in the future, and it's often only utilized to specify life-prolonging and end-of-life treatments that you either do or do not want. And very importantly, it's not just what treatments you do or do not want. A living will specifies the circumstances where you want those instructions to apply. Often we're talking about someone in a coma or a persistent vegetative state, or again, incurable or irreversible condition with no reasonable hope of recovery. Sometimes you see the term terminal condition, and terminal condition is usually defined in the law as either less than 6 months or less than 1 year. But perhaps if you may want your wishes to apply, even if you're in a more dire situation, maybe that's too soon for some. Maybe that's not soon enough for others, but not too soon for some. So there are ways that you can specify your instructions under what circumstances. So is a living will enforceable? The short answer is yes, if the living will provides clear and unambiguous guidance under the circumstances. Remember, we're talking about end of life here. So the law must be specific. That's partly why the Terry Chavez case lasted so long. And I'm sure you're familiar with some of the other cases that have been in the news over the years regarding individuals where there had been a dispute as to whether life-sustaining treatment could be withdrawn. And there's a famous quote from a New York case that said that if the court was going to make an error, they would err on the side of life. So you have to remember that's part of the court, thoughts and how the legal community views it. At the same time, we have a constitutional right to control what happens to our bodies. We have a constitutional right to say, no, I do not want medical treatment, and to decline medical treatment, even if it is life-saving treatment. So a living will allows us to express those wishes in writing. but they have to be very clearly stated in order for it to be honored. So it has to specify the medical treatment in issue and the circumstances. It can't just be, well, this person always led a very active life, and so I don't think they would want to have a feeding tube. No, it would have to be that you knew they didn't want to have a feeding tube if they were now in a coma and with no reasonable hope of recovery. So now the other thing I want to mention is that when you have a healthcare representative that is appointed, it's the healthcare representative that's making decisions, right? So even though you have a living will, it may not be, and this sometimes can vary by state, but in New York, in New Jersey, in Connecticut, it's the healthcare representative that's going to make the decision. Now, the representative is required by law to make decisions consistent with your wishes. So they must follow the living will. So it still will be honored, but it's going to come through the voice of the healthcare representative. And I also want to point out that we sometimes see this question about emergency medical services. Will they honor a living will? Will first responders honor a living will? And the answer is no, they will not, because a living will applies in the future and it requires medical determinations and a medical determination regarding capacity. So you must, that would have to be effectuated at a later time. The same thing, by the way, is true with respect to emergency medical services responding to the appointment of a healthcare agent. If an agent says, no, I don't want you to do this, if EMS is called to the house, and I don't want you to take my loved one, I don't want you to resuscitate them because they didn't want that. EMS can't honor the direction from a healthcare representative because, remember, I said the healthcare representative's authority only begins when you've been determined not to have capacity. That's beyond the scope of what emergency medical services and first responders do. So they'll always, that can be implemented later after the determination is made. So how do you make a living will? Well, there's different forms. In New York, actually, there's no standard form for the making of a living will. There's no specific statute that talks about how to make a living will or what the requirements are. But this particular website has one that, and that's why I've given you the link, that has forms that may be honored in New York. In New Jersey, there is a standard form for an instruction directive. That's what it's called, an instruction directive. We had a proxy directive to appoint a healthcare representative. The instruction directive is the equivalent of a living will. And it's very specific. And there's a link here for you if you're interested and you're a New Jersey resident. And it takes you through, this form will take you through various questions about cardiopulmonary resuscitation. Do you want it? Do you not want it? Under what circumstances do you want these to apply? In the New Jersey living will, interestingly, they make a distinction between, remember I talked about terminal condition. There's a distinction between a terminal condition being something less than 6 months or a year, and where you only have a few weeks to live. Do I want this to apply only if I have a few weeks, death is imminent, or I only have a few weeks to live? So that's a more narrow basis upon which you might want to express your wishes. You have that option on the New Jersey standard form. In Connecticut, I've given you two links. One is to the advanced directive for a living will. That's the first bullet. The second bullet you'll see is there's a combined form that Connecticut has. It combines both the appointment of a healthcare agent and the living will itself in one document. So that's also there for you to take a look at. How do you make a living will or an instruction directive? It should be signed and dated in the presence of 2 adult witnesses. Alternatively, in some states, a living will may be signed and acknowledged before a notary. So there are some differences between the states. If you look at the forms I've given you, you'll see those state forms will show you exactly how that can be signed. So what's the difference between a document appointing a healthcare agent and a living will? What's the difference? Well, a document in which you appoint a healthcare agent simply is appointing someone else to make the decisions for you in the event you're not able to do so. A living will or an instructional directive is a document that expresses your wishes about healthcare and is really sort of addressed to unnamed family, friends, healthcare providers, and facilities, because it could speak for you if you can't speak for yourself. It's recommended by many that you have both a proxy and a living will, although sometimes it can be limiting to an agent because the agent is required to make decisions in accordance with your living will, unless it's been revoked. And a proxy and a living will can be revoked at any time. And here I just want to caution you that the states have differing requirements for how to revoke a proxy and a living will. In Connecticut, for example, you must do so in writing. It has to be witnessed. So it's just something to keep in mind. Very often the making of a new proxy would automatically revoke the prior one. That's true in New York. But you'd have to check with your state depending on what could be done. Okay, let's move on and talk about a do not resuscitate order. What is that? It's a medical order directing no cardiopulmonary resuscitation in the event of cardiac or pulmonary arrest. What do I mean? If your heart stops or you stop breathing. That's all a DNR is. It is consistent with all forms of other medical treatment to be provided. So you can have a DNR and still have all other type of treatment. You can have a DNR and still have to be intubated because you're having trouble breathing, because a DNR only applies if you stop breathing. It's very limited. A DNR is signed by a physician upon your consent, and it only applies in a hospital or a nursing home. Now, I put a little asterisk next to physician because in some states, nurse practitioners and physician assistants are now authorized to issue DNRs. So it depends on the state that you're in. If you live at home in a private residence in the community, or you're living in an adult care facility, such as an assisted living facility, if that's where you're living, and if you want to have a DNR order, you must have, this is in New York, you must have a non-hospital DNR. Now, actually all across the country, there's something called a POLST. It's mostly known as a POLST, Physician Orders for Life-Sustaining Treatment. In New York and in Connecticut, it's known as a MOLST, meaning Medical Orders for Life-Sustaining Treatment. That's a document that crosses all care settings, and we're going to talk about it in a moment, but a non-hospital DNR or a MOLST or a POLST form can also document a non-hospital DNR so that it can be honored in that type of a setting as well. It's important to note that a DNR and a non-hospital DNR are effective immediately. This is not like a living will where I want this to apply in the future, in the event I have an incurable or irreversible condition. This is effective now. This is like a prescription. So it's effective now. It is a physician order. It's a medical order. And in this situation, first responders, emergency medical services, hospital emergency staff will honor a do not resuscitate order or a non-hospital do not resuscitate order upon presentation. They will honor that. So if you're at home and you're in hospice, you need to have a non-hospital DNR or a MOLST form, and it's going to be posted right on your refrigerator so that if someone called EMS, they could see that and they would honor that. In some circumstances, if you have not consented to a DNR yourself, your healthcare agent can consent to a DNR. Your healthcare agent has the authority to consent to a DNR, whoever your healthcare representative is. In New York, if you're in a hospital or a nursing home, and actually in a community setting in hospice, a surrogate decision maker can also consent to a DNR. So let's talk a little bit about the MOLST POLST forms, orders for life-sustaining treatment. This is a form that provides multiple options and instructions for persons who have a serious health condition and want to define their healthcare wishes when they're facing the end of life. I mean, when we think about it, as we get older, we may develop medical conditions, and when we're in our middle age, those medical conditions are managed, but there may come a time where managing those medical conditions is becoming more and more difficult, and the condition itself is perhaps more exacerbated. Maybe somebody has a chronic obstructive pulmonary disease or some other pulmonary disease, or they have an advanced cancer. If that's where that person is, where even an attempt to resuscitate them would likely not be successful, or they want their wishes to be applicable now, they don't want to be intubated, a MOLST POLST form is the only option that you can use to have both a do not resuscitate order and a do not intubate order. And so this type of form was really created to be completed, in stages as a person's health declines. So it's reviewed regularly, and you can continue to complete the optional instructions. I'll talk a little bit about the optional instructions too, because it includes do not resuscitate, do not intubate. You can ask for no tube feeding, or you may say you want a trial period of tube feeding. And only if you don't ultimately come off tube feeding do you not want to have it any further. So you can ask for a trial period. Same thing for hydration. You can ask for a trial period of hydration or no hydration at all. You can also opt for all of these measures to ensure that you're going to have all of these measures. You can include no transfer to a hospital if you don't want to be hospitalized. So there are many options, and there's also space to add more instructions. You can also ask for all comfort measures to be able to be provided, including pain management and pain relief. The MOLST form are, again, physician orders. In some states, it can be done, again, by a nurse practitioner or a physician assistant. And these medical orders are effective immediately in all care settings. It's a form that stays with you, whether you're home or in a hospital or in a nursing home or back home again, or an assisted living facility. It applies in every patient care setting. Consent for this type of form can be provided by you if you have decision-making capacity. And if you don't have capacity, a healthcare agent or healthcare representative can consent to the extent that they have authority to do so under your advanced directives. They can consent to all of these things as well. And there may be others who have authority. So if you don't have a healthcare proxy or a healthcare representative that you have appointed, for example, in New York, if you're in a hospital or a nursing home, there is a surrogate decision-making statute that would allow the surrogate to make that decision on your behalf, as long as it's made consistent with the rules and regulations of that law. So that may be anyone who has legal authority to make medical decisions for you would be able to make consent to these orders being issued on a MOLST or a POLST, consistent with the requirements and specifications of that law. So now I'm going to turn it over to my partner, Doris Martin, to speak about the next set of slides.
So now we're going to turn to the financial aspects of some advanced planning as opposed to the personal health care decisions. So one of the most important documents, in addition to the ones we've just discussed, for advanced planning so that you choose who is in charge of financial matters which can affect your health care and other personal matters, is to do what's called a power of attorney. Power of attorney forms used to be simple things that you could go into a stationery store, remember those, and pick one up and sign them. But because of the ease of access that nefarious people had and took advantage of people in compromised positions, the states have enacted more stringent laws that make these forms harder to obtain and execute without having you consult an attorney. So a power of attorney is an extremely powerful document that gives somebody, either immediately or upon the condition of certain events, usually concerning your incapacity or a period of time when you're not going to be available, to take care of every kind of financial matter, from dealing with your employer to making sure your salary gets paid, to speaking to your investment advisors about decisions that have to be made, to getting your mail and making sure your bills get paid, staffing, your healthcare workers and making sure they get paid, or caregivers at home, making birthday gifts to people that you've made all your lives to that you want to continue, doing sophisticated things like transfers and trusts to carry out Medicaid planning for yourself, estate tax planning. It's really the kitchen sink. If you don't do something like that, then nobody has the ability to make those kind of decisions for you without going to court, which is an extremely complicated, emotional, and difficult proceeding. Preparing a power of attorney is not very expensive compared to the rest of the estate planning documents that you can do, and it is dwarfed by the costs of having to go to court. So sometimes people are reluctant to give up control, and while a power of attorney can have conditions built in for when it's effective, and we'll get into that in a little bit, the point is that by you choosing who that person is that you trust to take care of your finances, you are exercising control and not having that foisted on you. For example, the people who are most likely to be appointed your guardian, unless it can be shown that they're not acting in your interests, are your spouse or your children. And if you have more than one child, there may be one that you would rather have in charge of your finances than another. And all of those people have equal rights within those groups. So it's very important. And you may have a friend or an accountant that you prefer be involved. And family members, for people who only have cousins or more remote relatives, those might not be the people that you want involved, and they would be the ones who legally, despite your friend of 40 years being the person that you would trust the most, who could come into court and take over things. And I'm sure you've read in the newspaper, there's always horror stories that people have had guardians appointed. It gets extremely costly. The court can appoint the person. They can appoint an attorney. The attorney can charge fees, and it can get extremely, extremely difficult. So it's one of the most simplest legal documents that would be presented to you, but it has the most impact on how things can be done. So there's different ones, like the healthcare documents. They can either be triggered by a doctor saying that you're unable to make reasonable financial decisions in your best interest, which we advise clients not to do unless it's the only way that they can wrap their head around signing this kind of document. Because if something needs to be done, you have to spring the power of attorney. You have to get the doctor to sign something. That physician is going to want to take care in making sure that that event has occurred and is valid. And it can delay things when there might be some economic detriment or need to act quicker. So it is possible. Typically, it's conditioned on one or two physicians, one maybe that's been treating you even, that could be required to make it effective, or it is effective immediately, and that means that the person you're appointed does have rights unless you choose to revoke it. So what I often do with clients is to say, you don't have to give this to the person you've appointed. You keep them in a safe place in your home. I keep one. And unless until that time comes, it's not given and distributed to the people you want to have act under it. Now, for the most part, if you're married, it's going to be your spouse 9 times out of 10 or 99 out of 100 times. Or it's going to be your children. Again, you can have more than one. Maybe one child is the one who's going to come and open the mail, and the other one's going to do the big picture things, and they can act separately or together depending on how much of a check and balance you want to put in. You can also, if you're extremely uncomfortable with this idea, you can appoint someone who has a right to monitor the situation. Sorry, my screen just went dark. Eve, can you pick up? I don't have a...
Yes, I can. I'm sorry. So examples we were talking about power of attorney forms, and Dee Dee was describing various types of powers of attorney, the springing power that happens upon an event.
Oh, I'm back.
Okay, good.
Oh, no, I'm not. Sorry. Keep going, Eve.
All right. So, apologize, everyone. Most powers of attorney are durable in nature, meaning that they will remain effective even if you lose capacity in the future. There are specific state requirements for powers of attorney. So as Dee Dee had mentioned before, as there had been some abuses, states became much more protective. And so there are certain requirements. For example, in New York, there's certain cautionary language that must appear on the power of attorney to be valid. And another requirement is that there be a special type of a rider if the agent is going to be authorized to give gifts and Medicaid planning. Dee Dee, if you're back, I'll let you jump in.
Okay. So in New York, for example, attorneys like to add various powers that let either Medicaid planning or estate planning and gift planning continue. And you have to specifically authorize that in a rider that has not only a notary involved, but 2 witnesses. And this is where New York was seeking to protect people from being taken advantage of. They wanted you to specifically state that you were authorizing the agent to give your money and property away for certain reasons. And that has to be specifically acknowledged. And that's a very important thing. Even I have been in many situations where a parent has had some kind of event and their children or their spouse wants to do Medicaid planning for them. And a straightforward power of attorney without this extra rider would not allow you to divest that person of assets for this purpose. So it's extremely important to have those extra powers, and dealing with retirement assets, creating trusts, all of that requires additional language. There's short form powers of attorney versus long forms. We prefer to use the long ones. And again, as in New York, Connecticut is a state that has to be done in a longer form to exercise those additional items. Another basic foundational document that you need to have is a will. Yes, there are rules in each state about who gets your property if you don't have one, and you can take care of passing assets through various forms of beneficiary designation and joint ownership, but there's always something that will require an executor or an administrator to be appointed, and it's much easier to have you choose who that is and sign a document saying who that person's going to be. It makes it less costly to get that person appointed, and it also allows you to vary from the terms of what the state would provide about who is entitled to be your executor and how your assets get distributed. It can also, because you're choosing the terms, prevent your family from having to argue over what you may have wanted, who should be the executor, who should get, your engagement ring or your car or your watch or certain accounts. There also can be reasons why, for either tax planning or a disabled beneficiary or a beneficiary who has their own issues other than that you could protect them from. Perhaps one of your children is a doctor and they don't want to inherit property outright. We tell our clients who are physicians, the best thing you can do is tell your parents to not leave you anything outright, but put it in a trust for you. If you create that trust, it's a whole other issue that doesn't protect you. But if you ask your parent to do it and even pay for them to go back to their lawyer to do this if that's important to you. We have increasingly see a need for people who have disabled grandchildren or children that would not be able to manage the money or are receiving government benefits that would be taken away from them if they inherited. So that's another reason. And in New York, there are big tax planning reasons why your spouse may not want to inherit everything outright, but rather have it in a trust under your will that they have access to and control of and are the trustee, so that the trust is not included in their estate and their estate stays within the New York exemption. New York is a use it or lose it cliff state, and if you don't take advantage of it, it is lost. So there are tax planning and other reasons. Also in Connecticut, the probate system, while the court is friendly and easy to deal with, they have a lot more administrative rules about continuing trusts and accountings, and a revocable trust is standard estate planning now. It didn't used to be so familiar to us. It was something you only saw in Florida and California, but most attorneys will advise that, and it doesn't really change the cost of you doing your planning, that you do what's called a revocable trust as well. A revocable trust can avoid having to go to court. You can still pick that person who's the administrator of the estate. They're called a trustee, but you don't have to have the lawyer prepare the forms to go to court. You don't have the delay of going to court. Right now, believe it or not, the surrogates courts in New York State are not deemed to be essential. You can only get someone appointed in court if you have an emergency. You know, there was a closing that was going to happen, or someone doesn't have access to money from other sources, and you have to make a special, additional, costly application. If you had a revocable trust and your assets were in the trust, that would be completely unnecessary. And in these times of volatility and delay and uncertainty, we see people asking to get their trust done. How do I put my assets in it? Because now is the time to take a hard look at this and say, why do I need to leave it up to the state rules and the state courts? I want my family to have access to things right away. In order to make the trust effective, you really have to put assets into it. You can't just sign a document that says I'm adding all my assets in. You have to change deeds. If you have a co-op, you have to ask the board for permission. If you have a mortgage, you have to tell your mortgage bank you're doing this. You can retitle accounts in the name of the trust. You could designate the trust as beneficiary. Now, we're not saying put that down as an IRA beneficiary, because that has other consequences which we are beyond the scope of this, but it's not so simple. The document's the easy part. The legwork that goes into funding it. Between a husband and wife, this isn't as important except for tax planning reasons, but certainly if you are the surviving spouse, you want to make things easier for your children by taking care of this now. And the revocable trust is just like a will. It appoints who's in charge, and it says how the assets go. It just takes the attorneys and the court out of the equation and makes it easier. Many assets go outside a will. It's important to understand that you can say something in a will that you want your estate divided a certain way, or you want a certain account to go a certain way. But if you've designated something on a beneficiary form, or you hold it jointly with someone, or you've designated it in trust for the old Totten trust form of accounts, or you've designated a beneficiary on insurance, life insurance, annuities, CDs, IRAs, those pass in accordance with those designations. They don't pass in accordance with the will. So again, that legwork of looking at all your assets, dealing with your financial advisors and your accountants and the attorney to make sure it all coordinates is the critical thing. If you don't do that, that trust is not worth the paper it's printed on. That will isn't worth the paper it's printed on. A will is not a magic wand. A trust is not a magic wand. You have to make sure that the assets coordinate with it. Don't listen to the person in the bank who tells you to name your kids or your spouse as beneficiary automatically. You need to go back to the attorney who helped draft the documents and say, is this what makes sense? And now we're back to Eve.
Thank you, Dee Dee. We're going to talk a little bit about organ and tissue donation. This is a much needed thing across this country, and there is an organ and donation network. You can indicate your wishes with respect to organ and tissue donation in many ways. You can make that indication on the document that you utilize to appoint a healthcare proxy or a healthcare representative. You can register online, and there are 3 different websites that I've given you, one for New York, one for New Jersey, one for Connecticut, where you can actually register online what your wishes are with respect to organ and tissue donation. You can also indicate your wishes at the Department of Motor Vehicles. It can be on your driver's license, or it could simply be done while you're at the Department of Motor Vehicles in person. In addition, your family is authorized to make anatomical gifts like this after your death, unless you state to the contrary. So if you don't want that to be done, you can also make that statement, make your wishes known. Dee Dee, you want to talk about disposition of remains?
Yes, sorry, I just have to unmute my phone. In the event of your passing, it might come as a surprise to certain people that a spouse who you are estranged from is the person who has to approve your funeral arrangements, or you have more than one child and they do not agree, or you're estranged from one of them. And in most happy families, this will never come up. But if you have a specific person who might not be in that order, spouse, then children, then grandchildren, siblings, etc., or parents, if you still have them, then you do want to specify who that person is, that agent, to control what you want. You can also give that person specific instructions. As Eve was saying before, sometimes people, just as in healthcare, have certain wishes that they want to be carried out, and they don't think that their family, for cultural or religious reasons, is going to follow. So every state, and we've given you the links here for Connecticut, New Jersey, and New York, has documents that allow you to name an agent and to express any special wishes that you may have, what inscription you want on the stone, who you want to be buried to or not, what kind of service you want to have. Do you want an open casket? You don't. You want certain hymns or psalms read, or a certain person. You don't want A, B, or C. So these forms all allow you to do that. And then that also takes the burden off of your family who are grieving and they don't, had never discussed this with you and they don't know what you want.
It also allows you to choose cremation if you don't want to be buried. So that's another option.
And that's one of the things that people often want it specified, because their family may not want to honor that, especially if they've never expressed that wish to them before.
Or it may be against cultural or religious beliefs, but that's your wish anyway. So again, it's a matter of being able to effectuate what your wishes are. So I'd like to spend sort of the end of this presentation talking about the execution of documents via video conferencing. During this pandemic, both in New York and in Connecticut, the governors have issued executive orders that allow for certain documents that are usually notarized or witnessed to be able to be executed while people are at home, or executed remotely, I should say. In New Jersey, it was done as an actual law that was signed by the governor later and made into law. So there is an option for executing documents remotely. But Dee Dee and I will tell you, and we've listened to many lawyers looking at these requirements, that it is an extremely complicated process and one that is not entirely agreed upon in terms of how to do it. So I would first caution everyone that if you are going to be executing these documents at home, if you do not, for example, if it's a healthcare proxy and if you live in a home where you have multiple adults who live there with you and they're not going to be the ones named as the agents, then maybe you can do these things at home without an attorney. But if you have something that has to be notarized, or it is otherwise going to be signed remotely, we would strongly encourage you to consult with your attorney and don't try this alone. I do want to give you some examples of some of the differing rules that vary between these states. And some of these are common themes and some of these are different. So for example, all of the states do require that if you're signing remotely, whoever is going to be notarizing your signature has to know you personally. There has to be an active video conference, and you have to be known to that person. If you're not known to that person, then you have to present valid photo identification. And here the states differ. In New Jersey, for example, there has to be 2 forms of government issued ID, photo IDs. So, you know, in Connecticut, there are other rules as to what has to be transmitted prior to, you know, or at the time. I mean, I'm sorry, you're not permitted to forward these documents prior to or after the signing. It has to be done at the time. The video conference has to allow for direct interaction between you and the witnesses and the notary. There can be no pre-recorded videos where you're going to send them the video of your signing. That's not going to work. Depending upon the state that you're in or the type of document, you may be required to be physically present in the state of your domicile and to so state that at the time. So for example, that's part of the Connecticut executive order. You must be physically present in Connecticut to sign before a notary public. That's not true in the New York order, but again, you know, it depends on what type of document you're signing. All the participants, the signatory, so you, the witness, the notary, have to be able to confirm the document that's being signed. It's not clear exactly how that's going to be done, but there you have to confirm what that document is. And depending on the state and the type of document, a legible copy of the entire document and absolutely the signature page must be transmitted to the witnesses and the notary by facsimile or electronic means the same day of signature. So again, these vary between the states. The original signed documents must be returned to the notary or the supervising attorney within a certain period of time. That's a requirement in New York and in Connecticut. In some of the states, an audio visual recording of this entire signing act must be required, you know, must be made by the notary. So they have to have that capability of having a recording of this audio visual signing, and they must retain that audio visual recording for years. The number of years depends on the state. And proof of the remote execution may also be required to be maintained for a certain number of years through other measures. So there are a variety of very significant rules regarding how to ensure that this act is done properly and that it is done consistent with the remote authorization requirements and also consistent with the requirements of the laws themselves. Because remember, wills are not signed in the same way that a healthcare proxy may be signed or that a power of attorney may be signed. There are different rules regarding how these things get signed. So there has to be, that process has to be able to be essentially replicated through this video conferencing technology, and how to get that done is something that attorneys are certainly talking about and sharing different ideas about how to do it properly. And again, I would caution you to consult with your attorney to do this and don't try to do it on your own.
I want to just I'm sorry, I just want to make one point about signing your documents. While it may be difficult or impossible or inadvisable for you to go to an attorney, and most attorneys' offices are not open, and if they are going to meet with a client, they will do it in a hallway or even the parking lot. Well, they'll set up a table and everyone keeps their distance and brings their own pens, and then you don't have to go through all this video conferencing and scanning. You could also, if you live with people who are not named in your document as a beneficiary or a fiduciary, you could have 2 adults, in-laws even, you know, who are not being named, act as witnesses, and that would get rid of the need. You don't need a notary to have a valid will, you just need 2 witnesses. So that's one thing, and you can always take care of other documents that require a notary later. A trust in New York also doesn't need a notary, you can just have 2 witnesses. And if you don't have people you live with, but you have neighbors or friends who are willing to just be in your driveway so that they can see what you're doing up on your front step, and you can speak to them and they can hear you, you can all keep your distance, bring your own pens, and that might be a way to take care of it if this video conferencing and remote documentation is daunting, which it is. It's like producing a play, and until you've done it a few times, it can often not be done properly, and it can be very costly too to try to take care of it. It adds a layer to your expensive estate planning.
And in New York, there's a potential requirement that the whole thing be repeated within 30 days in order to continue it. So this is only going to be, this remote execution of documents, this option is only available during this public health emergency. So each state has different periods of time for when they've declared the public health emergency. And so these remote options only exist during that time. And of course, the state may extend that period of time, but it's just something to consider. So I think Dee Dee's absolutely right that if you can share the document with others that you live close with, and it's something that does not require a notary, for example, or if you know someone who's a notary, I'm a notary, I can notarize something that, you know, my husband signs where I'm not a beneficiary, I can notarize that. So if you happen to have that option, you certainly can utilize that, and that would make it a whole lot easier. And that's partly why we have provided to you some of the links to the forms that you can download, and it's very clear how to fill them in. And I would just always advise you to read them thoroughly, read the instructions, and make sure you're filling in all the blanks. So I would
use this crisis as the fire to put under yourself to get these planning documents in order when it has passed, if you can't get it done beforehand. Because now we're seeing people in situations where they're trying to get things done, and it's much more difficult, it's more expensive, it may be physically impossible because they don't have this scanning technology, or they are living isolated in suburbia where they can't get it done. So as soon as the coast is clear and we're all allowed to meet again under, I'm sure, new rules about how we greet each other and things that we share physically, that you get back to your estate planning if you hadn't completed it and get it done, or if you had never started it, get it started and done when you have a chance to do it without doing it under these conditions.
And just some final thoughts and suggestions. We recommend that you do contact your personal attorney to go over these matters. Many personal attorneys are available and working remotely and will be able to talk with you. And even if you're not able to execute these documents now, Dee Dee's absolutely right. You can start the process to talk about what to do in the future. You can download the forms that we've recommended. We're using we're using state websites. So this is coming from governmental websites in terms of those forms. And if you're looking for other materials, we would always caution you to go to the government website or to the State Bar Association website, because there's a lot of information available to consumers about these kinds of things on the State Bar Association websites. Frequently asked questions, so there's a lot of material there. You certainly should use this as an opportunity to talk with your family members, your physician, and those you trust about your goals and preferences of treatment. Even if you're not able to make a proxy document or an informational directive, instructional directive, or living will at this time, you should certainly share and start having those conversations now. It's important for people to understand. I can tell you from my own experience, I was the agent for my parents, and I made sure that over lunch, when it was just us, that we have a chance to talk about these tough issues. So it's important to start those conversations. And some of these websites, I think like the caring.org website and the New Jersey's website also has information as to how to start the conversation. So those are good tips as well. And it's helpful for people even now to know what your wishes are. So if anyone ever says, well, how did you know? You can say, well, because he told me or she told me that that's what she wanted. And then lastly, with respect to estate planning wishes, same thing. Talk with your, contact your attorney if you have one and start talking about your estate planning wishes. Talk with your family members and trusted advisors, your accountant and your financial advisors as to what your wishes are so you can start to make a plan. So again, I remind you that we are now at the end of our session. And so if you have any questions, we'll certainly try to answer those questions. Everyone will be entitled to have access to the webinar and to the slides. So you don't have to make notes. They'll all be here. And I'm just going to try to take a quick look to see if we have anything and try to answer some of those questions that have been posed. So if you just give me a moment, I will try. So here's one question. How do the will and revocable trust fit together?
So the will is in the instance where you're using a revocable trust, the will is what we call a pour over device, where all it's doing is putting the assets in the trust that you may have forgotten to get around to or couldn't when you were alive. And the trust is like your will would have been, where it says where all it goes. So they do agree. One refers to the other, but the trust is the document that has all the instructions about what you want. And then the trust, depending on what you do, can protect someone for Medicaid, they can protect someone for asset protection, they can protect taxes. They are a blank slate that, just like a will, can do a million different things.
So the follow-up to that question was, how does the trust protect from taxes?
It really depends. It's not a function that's special to the trust. It's just like a will. There are certain tax planning devices that you can have in a will or a trust. So it's not something that's special to either one of them.
Okay. Yes, you can receive a copy of the presentation. All right, very good. I think that's really all the questions that I can see for now. Thank you everyone for joining us. It's much appreciated. We're going to end the presentation at this time. Thank you. Bye-bye. And stay well.
Thank you.